So after the Supreme Court has discussed the opinion, or excuse me, discussed the case in secret, they will assign the writing of an opinion to one of the justices. There are different types of opinions that will be issued by either the court or by individual justices. The most important type of opinion for policy making is called the majority opinion. The majority opinion is the opinion of the court. The opinion will explain which side wins, and more importantly, for purposes of creating a precedent, why that side wins. So by writing this opinion, the court is saying this is what this provision in federal law means, or this is what this provision in the U.S. Constitution means. Far more important for the rest of the country is why the law means what it means versus which side wins. If a justice agrees with the outcome of the case, and that is to say they agree with the decision of the court regarding who won, but they have a different set of reasons, or they disagree with how the law is applied, they can write what is called a concurring opinion. Again, what they're saying is, I agree with the outcome of the case. The side who won should have won, but I disagree with the legal reasoning that the court used in arriving at that decision. Another type of decision that can be issued by a justice is called a dissenting opinion. In a dissenting opinion, that's where a justice is saying, I disagree with the outcome of the case and I'm going to explain why. I obviously have a different set of reasons as to how we should have reached our decision. I disagree with how the court has interpreted the law or the Constitution, and I'm going to explain what I think would be the right way to do things, the right interpretation. Finally, if each justice gives his or her opinion individually, this is called a plurality opinion, and this is the least beneficial type of opinion with regard to the creation of a precedent. So, what factors contribute to Supreme Court decision making? What impacts the decision that the Supreme Court? What impacts the decisions that the Supreme Court makes? The most important factor that goes into creating a decision of the Supreme Court is precedent. The United States legal system, again, is a common law legal system, and precedent has immense value. This is not to say that it can't be changed or overturned, but overturning it happens only with great reluctance. So if an issue has been settled, if a provision of the Constitution has been interpreted, then it is only with great reluctance that the court will reinterpret it or directly overturn that. The ideology and party identification of a member of the court obviously would impact their decision-making process. Justices that are conservative tend to render conservative decisions, and justices that are liberal tend to render liberal decisions. In fact, that ideological background is perhaps the biggest predictor of future court decision-making, although it is not perfect. Then there's the perception of the role that the judge has. How does the judge perceive his or her role? Do they believe in judicial activism? Do they believe in judicial restraint? And this is not necessarily the same thing as ideology. You can be a liberal judge but believe in judicial restraint. You might believe in liberal policy but believe that the judiciary is not the best way to achieve that goal. Public opinion. Yes, public opinion enters into judicial decision-making. Public opinion enters into judicial decision-making a couple of different ways. Number one, public opinion impacts who will become president, and it impacts who's going to be the composition of the U.S. Senate. That combination obviously is going to impact who will be appointed and who will be confirmed. Public opinion that would be, or a public opinion that would be against a particular nomination might lead to that nominee's rejection. So public opinion impacts who gets on the court. Public opinion also impacts the decisions that the court makes itself. This is not to say that the court goes out and takes an opinion poll every time they want to make a decision. But if the court's decisions are to be obeyed, they have to be within the boundary of what is considered acceptable. If the court consistently makes decisions that are outside the bounds of what is considered acceptable, the public is less likely to follow them. It should be mentioned that the court in no way has any power to enforce its own decisions. Again, the court lacks the power to enforce its own decisions. It has to rely upon the political branches, the Congress and the executive branch, to carry those decisions out. If the opinions issued by the court are considered outlandish or outside the mainstream, particularly if there are multiple decisions that are viewed to be outside the mainstream of what the mainstream considers acceptable. Those decisions might be ignored by the President and by the Congress. What could the court do about this? The simple answer is nothing. The court cannot force an elected executive, such as the President or the Congress, to obey their decisions. They have to rely upon their legitimacy. So this thought process definitely enters into their decision-making process and also into what cases they will accept for review. Then there are different views on the meaning of the Constitution. The two basic ones are going to be the intent of the framers and the living document theory. The living document theory, or the view that the Constitution is a living document, is that the Constitution should be interpreted consistent with the changing needs of an evolving country. Then there is the intent of the framers view. The intent of the framers view holds that the Constitution should be interpreted consistent with the intent of the framers. So the task of the judge is to ascertain what did the framers, the writers of the Constitution, mean when they wrote it down. There are several intellectual problems with this intent of the framers view. Number one, did the framers speak with one voice? Number two, how do you ascertain what they meant? Notes on the Constitutional Convention are sketchy. James Madison's notes of the Constitution are sketchy. The best interpretation, or the best source of what the framers might have meant, would be the Federalist Papers, but that was only authored by 3 of the framers. And if you recall, there was the disagreement among the framers after the Constitutional Convention as to what different provisions meant. A much more intellectually honest, in my opinion, way of looking at it is originalism, that the words listed in the Constitution should mean what they mean or what they meant at the time. Whether this is an advisable interpretation or advisable view or not, that's beyond the scope of the course, but at least this viewpoint is intellectually honest in my opinion. Then there's collegial interaction. The fact that justices are intellectual, they are engaged in intellectual activity, and they do interact with one another, can cause justices to reevaluate their positions and evolve their thinking over time. Sometimes this is manifest as, for lack of a better term, judicial drift. A judge might be appointed who has a track record of being conservative, and they might begin to track toward the middle, or someone who has a record of being more liberal might track toward the middle, becoming a little bit more conservative over time. Again, past performance or past interpretation and past behavior is the best indicator of future behavior, but this is not to say that change cannot happen over time. So, public opinion in the court, does it matter? And the simple answer is yes, it does. It does impact judicial decision making. Whether it should or shouldn't is beyond the scope of the course. The fact is the court exists in a political world. While it is true the framers did create the Supreme Court or give those justices lifetime terms during good behavior to insulate them from public opinion, but it doesn't mean that they are 100% removed from it. As previously mentioned, the concept of legitimacy is important. Will the decisions of the court be viewed as being legitimate? Not necessarily will people agree with them, but will they agree that the decision was made in a legitimate manner? If they disagree as to the legitimacy of the opinion or begin to doubt the legitimacy of the court and its ability to make those decisions, then it is far more likely that the court's decisions will be ignored. Perhaps the best example of this is Brown versus Board of Education. Brown versus Board of Education, the landmark U.S. Supreme Court case that declared that segregation has no place in public education because segregation is inherently unequal and violates the 14th Amendment Equal Protection Clause. Obviously, this decision was not too well received in the American South. You will notice that the court did not make very many controversial decisions after that. So while the court made a decision that was very controversial, it was careful not to make any more decisions that were viewed as being controversial for some time after this decision. What are the checks on judicial power of the court? The system of checks and balances in the United States does provide some limitation or checks upon the decision-making power of the Supreme Court.